Justice Barrett?
So I think the questions that Justice Kagan asked you are hard because they seem like they're not creating. I mean, you're on your strongest ground when you're talking about her sitting down and designing and coming up with the graphics to customize them for the couple. So let me just clarify exactly what your position is on things that are already created in the past. What if it is plug and play? I don't know that much about website design, so I don't know how it could be plug and play. I'm sure it can be. She does the programming, the coding, she has stock pictures, and she sells that as a product, and the customers, you know, Mike and Henry, or, you know, Lily and Luke, fill it in themselves. Is that protected?
It is not protected in the same way that if you sold a Bible commentary, you wouldn't be able to decide whether the Bible commentary will be burned or it will be used in a church service. The stream of commerce, it's been put in the stream of commerce.
Okay, so why is it different? Justice Kagan said, so maybe you do create customized websites, and you've created one for, you know, Lily and Luke, and then, you know, Mike and Henry see it and say, you've created that already, we love it. We want to buy it. Don't create anything new for us. Just give us exactly what you did for them. Why is that different than plug and play, or is it?
It is different. I mean, first of all, if I take your hypothetical on its face, we would be selling essentially she would be creating a website that's exactly the same with the same pictures and text and graphics and videos of an opposite-sex couple and selling it to a same-sex couple, which seems highly unlikely. They wouldn't use that to celebrate their wedding. So in terms of if you're asking her to change the text, to change the logistics, to change the names, you're changing bride and groom. You're changing the couple's name. You're changing, we know context changes meaning. Justice Ginsburg said that in Yates versus United States. Even the same words have different meaning. God bless this marriage means something different. My body, my choice means something different to an anti-vaxxer or a pro-abortion opponent or proponent. So in that sense, that's why she would object if she were changing the words in the text. But of course, she would sell the same website celebrating an opposite-sex wedding to a same-sex couple.
Okay, so context changes meaning. What if instead of a graphic designer, she's a songwriter, and she writes a song, you know, let's say At Last or Wind Beneath My Wings or something that people want to dance to at their wedding. And the lyrics are out there, you know, it could be played at a heterosexual wedding or it could be played at a gay wedding. Once the artist has created that song, can the artist say, but I'm not licensing it to be played at certain kinds of weddings?
No, I don't think the artist could. I'm not familiar with the licensing rules and how all that would apply in terms of a contractual relationship. But in terms of just having a song used at a wedding, assuming that would otherwise be okay, there's no other legal rights, she couldn't. That was in the stream of commerce. But I think it's important to point out that if that artist were being asked to perform that song in a live way, for example, sang at a Democratic inauguration and they were asked to perform at the Republican one, under Colorado's theory, they could be compelled to do so in a number of jurisdictions. 19 jurisdictions have political ideology. And when we think about that, there's no limit to what the government could compel.
Thank you.